Hello and welcome back to Aayu Pathshala, and this is the fifth video in the series of Indian Polity. And today we are going to walk through two of the most important milestones in the constitutional history of India. The story of our constitution is not just about the articles and schedules in it. It is a living document. That means it has to evolve itself over time. It get matured and have been repeatedly tested in the courtroom. Over the decades, several landmark cases have reshaped the balance between the people, the parliament, and of course the constitution itself. These judgments not only clarified the limits of the power, but also strengthened the foundations of our democracy. Among these historic decisions, two cases stand out for their long lasting impact. And the first is the Kesavananda Bharati case of 1973, which gave us the celebrated basic structure doctrine and ensure that no authority can damage the core values of our constitution. And the second is the addition of the ninth schedule in our constitution. Together, these cases tell the story of how Constitution protects itself and how the judiciary safeguards the ethics and the core values of the Constitution. So, with this background, let us begins the today discussion. But before this, let us quickly recapitulate what we have covered in the previous video. In the previous video, we have discussed about the preamble of the Indian Constitution, and we have understood the different terminologies and the amendment of the preamble, wherein we have discussed in detail Article 368 and whether the preamble is the part of the Constitution and different cases related to it. So today we are going to see the two landmark cases. One is the Keshwananda Bharti case, and another is the case related to the insertion of the Schedule 9 in the Indian Constitution. So, we have discussed that under Article 368, the Constitution itself defined two things. First, it said that under Article 368, the Parliament has the power to amend the Constitution. Power of the Parliament to amend the Constitution. Second, it defines the procedure, the method, how the different provisions or the different part of the constitution would be amended. Now, when we say that the parliament has the power or authority to amend the constitution, then the next question arises: to what extent? To what extent? Okay. To what extent the parliament has the power to amend the constitution? For example, we have seen that the Article 14 says we have right to equality. Article 14 says that we have right to equality. That is, everyone is equal before the law. So, can tomorrow the parliament pass a law which says that the which says that only men will apply for government jobs, not women? That is, equality is not served. Can parliament is parliament authorized to pass a law such that only men will get the opportunity to apply for the government jobs and not the women? That is, on the basis of gender, we are discriminating. That is, we are limiting the opportunities on the basis of gender. But Article 14 says that we have the right to equality, and also Article 14 and Article 15 and 16 says that discrimination on the ground of gender is prohibited. So, can the parliament pass such law? No, it is obvious that the parliament could not pass such law. And why? Because the Article 13, Clause 2 of the Constitution comes in contradiction with that. Article 13, Clause 2 clearly states that the Parliament cannot pass any law cannot pass any law which that means takes away, abridge means takes away the fundamental right of the citizen. That means Article 13 Clause 2 says that the Parliament cannot pass any law which abridges the fundamental rights of the citizen. That means Article 13.2 prohibits passing of any law that violates the fundamental right, that prohibit the citizen to exercise their fundamental right. And hence, here we can clearly say that Article 13 Clause 2 is a hero which prohibits Parliament from passing such law. Okay, that is a valid point. Now, what if the Parliament changes Article 14 itself? What if the Parliament changes Article 14 and says that right to equality, says that right to equality, that is, everyone is equal before the law, except when it comes to application of job. Parliament can amend or simply it nullify Article 14. Parliament can do that. Yes, it has the power under Article 368 to amend the Constitution, and Article 14 is the part of the Constitution. So the Parliament can, by the procedure that is detailed in Part 2 of the Clause 2, Subclause 2 of the Article 368, can nullify Article 14 itself. Now, since Article 14 is nullified, that is, right to equality is no longer valid, and now 13 clause 2 does not apply on the prima facie, on the very beginning. Why? Because it says that any law that abridges the fundamental right, but the fundamental right itself has been nullified, so there is no contradiction. So can the parliament do such thing? Can the parliament manipulate such thing? That was the big question. That means, can the parliament is in authority to amend the fundamental right? That is, can they amend the fundamental right? And if that is the case, Article 13 Clause 2, that was hero a moment before, also become bounded. That is, there is no fundamental right concerning to such situations. So automatically, this law, as per Article 13 Clause 2, become valid. You're getting the point what I mean to say. That is, if the parliament has such powers to amend the constitution, so it can also amend the fundamental rights. And if fundamental rights become null or gets amended, then Article 13 Clause 2 become no longer powerful to protect the fundamental rights of the citizen. So now there arises two questions. There arises two questions. Number one, Article 13, Clause 2, whether it should be applicable to amendment, constitutional amendment or not. Amendment or not. Article 13, Clause 2 is applicable to the parliamentary laws, that is, any laws cannot be passed if it abridges the fundamental right, takes away the fundamental rights. But is 13 clause 2 is applicable to the constitutional amendment? That is, if by amending the constitution, the parliament is taking away the fundamental right, whether that is applicable, that will be counted under Article 13 clause 2 or not. If it is counted under Article 13 subclause 2, then obviously the parliament cannot amend this, cannot nullify this, because you cannot take away the fundamental rights of the citizen defined in the constitution by amending the constitution. If 13 clause 2 is applicable to the amendment of the constitution, yes, 13 clause 2 is applicable to the parliamentary law, that is clearly mentioned. But whether it is applicable to the constitutional amendment or not, that is the matter of interpretation. And who is supreme for the interpretation of the constitution? Yes, very well understood. It is the Supreme Court. Now, Supreme Court will only decide whether 13 clause 2 is going to be applicable on the constitutional amendment or not. If 13 clause 2 is applicable to the constitutional amendment, then the parliament cannot amend the constitution and takes away the fundamental right. And if it is not applicable, then the parliament is in full authority to amend the constitution and takes away your fundamental right. So the first case in this concern came into notice in the year 1951, and that case was known as Shankari Prasad versus Shankari Prasad versus this Union of India case. In this Shankari Prasad versus Union of India case, the parliament clearly said that the court clearly said that yes, the parliament has absolute power under Article 368 to amend the constitution. It says that the parliament power to amend the constitution also includes the fundamental right, that they can abrogate the fundamental right, they can nullify the fundamental right by amending the constitution, not by passing the laws. And hence they added that the amendment under Article 368 is not law, it's not ordinary law. That is, any amendment that you are making, for example, you are nullifying the Article 14, that is an amendment to the constitution, and that is not considered as a law. And if that is not considered as a law, then automatically the 13 clause 2 will not be applicable, because it is applicable only to the law passed by the parliament. So Sankri Prasad versus Union of India case upheld that yes, the parliament the parliament can amend the fundamental rights. That means 13 clause 2 does not include what? Constitutional amendment. It does not include constitutional amendment. Yes, if it includes constitutional amendment, that means it itself, the article is so much powerful that it will not allow the amendment of the fundamental rights. But Supreme Court in 1951 said that yes, you can amend the fundamental right. That is, the parliament can amend the fundamental right as well. So now let us go to the next important case in the series, and that came up in 1965, where in Sajjan Singh, the case name is Sajjan Singh versus State of Rajasthan, which also upheld the above judgment. It also said the same thing, that the parliament can amend the fundamental right by bringing an amendment to the constitution. And Article 13 clause 2 only applicable. That is, he said that in this case it was clearly mentioned that Article 13 clause 2, there are basically two types parliament has. Let us understand this at this point. The parliament has power to make laws, and it can pass two types of laws. Number one is called the ordinary laws. That is the power given under Article 245, say 246. And another is the constitutional amendment, which is given under Article 368. So Article 13 clause 2 is applicable over here, that is ordinary laws passing by the parliament. It is not applicable to the constitutional amendment, and hence you can take away the fundamental rights of the citizen by amending the constitution, which is not under the preview of the Article 13 clause 2. So both the cases supported the parliament power to abridge the fundamental right. And see why Kesavananda Bharati case is considered as one of the historic case. The reason behind, up till this point, that is up to 1965, the parliament was absolute power. Tomorrow, the constitution under part 3 defines certain fundamental rights which you can directly demand. It is your right, आपका अधिकार है, आप demand कर सकते हैं. And the court and the state, that is, you can go to the court and say, I have this as my fundamental right, and it should be given to me. And then the state, that is the government, will be liable, will be bounded to make them available to you, because it is a fundamental right. That is, it is enforced by the court. So tomorrow, suppose if the parliament is so much powerful, they may reduce your fundamental right day by day. They can reduce all the fundamental rights, and nobody can do anything, because clearly in 1951, 1965, both the cases, the Supreme Court held that the Article 13 Clause 2 will not be applicable to the constitutional amendment, and the Parliament can amend the Constitution, can take away the fundamental right only by the bringing an amendment to the Constitution. I'm repeating the words so that you could get a clear idea, clear picture on your mind. This is a very important point that I am discussing right now. Then again, more important case came which overturned the previous two judgment of the Supreme Court, and the year was 1967. And this was the case of Golaknath case. IC Golaknath, Golakh Nath case versus State of Punjab. And here the Supreme Court overturned the previous two decisions and said that no, Parliament cannot amend the fundamental right. Right. The Parliament cannot amend the fundamental right. It says it's strictly prohibited that the Parliament cannot amend the fundamental right. Now, the above three cases brought too much confusion that whether the Parliament can amend, cannot amend. In the previous two, now Supreme Court is the supreme law interpreter of the country, and if it said sometime in the past or it has made some judgment, obviously that is based on the interpretation of the Constitution. Now, in the previous two judgment, the Supreme Court said that yes, it can amend, and in the 1967, the Golaknath case versus State of Punjab, the case clearly, the judges clearly, the statement said that the Parliament cannot amend the fundamental right. Yes, they can change, they can bring about the amendment in the remaining parts of the Constitution, except the part third, that is, except the fundamental right. Now comes the Kesavananda Bharati case. And Kesavananda Bharati case is a landmark judgment. Kesavananda Bharati case is a landmark judgment. Kesavananda Bharati case 1973. This was a 13 judges bench, one of the largest judges bench decision ever in the history of the courts, and the decision was given by 7 is to 6. That is, 7 were in the favor of what the decision came, and 6 were against to that. Keshwananda Bharati was basically, we can say, a Hindu saint, and he was from Kerala. And in the Kerala, there was a mutt, which was named as the Edner Mutt. And Edner Mutt, the government, it was the within the mutt there was this mutt was basically in the ownership of large land, and the government of the Kerala has taken away some portion of the land from this mutt. The ownership was to the mutt. It was a religious land, but the state of Kerala, under the land reorganization act, took away some of the portion of the land of this mutt. Now, this person, Keshwananda Bharati, was very vigilant. He was well aware of his fundamental rights. So he went to the Constitution, he went to the Supreme Court, because if your fundamental right is violated, you can directly go to the Supreme Court and can complain to the court that my fundamental right has been violated, and you, my lord, you are the protector of the Constitution, you are the final interpreter of the Constitution, you give me the justice, and I want my fundamental right back. So it would be the duty and responsibility of the court to ensure that your fundamental rights are made available to you. So this man Keshwananda Bharti also went to the Supreme Court and he said that, my lord, constitutional fundamental right under Article 25, Article 26, Article 19, Clause 1, Clause F, and Article 31 is violated. And my lord, I plea before you, I request you to please order the state, that is the government, to give my fundamental right back. So, what was the fundamental right? Article 25. Article 25 says that every citizen is free to practice, to profess, and to propagate their own religion. He said that the land which was taken for the religious activity, which was under the administration of the mutt, has now been taken up by the government. And if they take away my land, where do I profess and preach my religion? Under Article 26, which says that you have the right to manage the religious institution. So if I have the right to manage, to control, to own my religious institution, why did the state interfere and they took away my property? He said that my rights under Article 26 is violated. My rights under Article 26 is violated. Also, the right under Article 19, Clause 1, Clause F, which says that I have right to acquire, to hold, and dispose my property is also violated. It was my right to hold that land, but that has now been taken away by the government. Also, my lord, the Article 31 of the Fundamental Right, that is Part 3 of the Constitution, says that no person shall be deprived of their private property except by law and with compensation. And with compensation. So these are the violations of my fundamental right that the state has committed against me. Now, the Supreme Court was to decide that, and you already know that the reforms were going on within the entire country. The land were taken from those who had the surplus amount of the land and were given to those who were deprived of their land. So, under that scenario, the Supreme Court had to decide what would be the case. Okay, and then Supreme Court came up with a judgment, and he said that yes, the the Parliament has the right to amend the Constitution, including the fundamental right. That is, it overturned the judgment given in the Golaknath case, and it said that yes, the Parliament has the right to amend the Constitution amend the Constitution, and that also includes the fundamental right. That means, yes, the fundamental right is also the part of the Constitution. And Article 368 describes how the amendment of the Constitution. And Part 3, that is the fundamental right, is the part of the Constitution and it can also be amendment. But, and this but is what is very important. He said, but there should be some limitation. There should be some limitation. What should be the limitation? This The court said that yes, the parliament has the right to amend the constitution, including the fundamental right, but there should be some limitation, and this limitation is what has changed the the balance of power between the parliament and the constitution. So the parliament now can amend any part of the constitution, but with limitation. What was the limitation? It says that the parliament cannot destroy the basic structure of the constitution. What is the limitation? Parliament, yes, you can do anything, but you cannot. What is the limitation? You cannot destroy. You cannot destroy the basic structure of the constitution. Destroy the basic structure of the constitution. And now, what is the basic structure? Then, at that time, the the judges, the court laid some of the point and said that these are the basic structure. You can do whatever you want to do with the constitution, amend whatever amendment you want to bring. You want to delete some provision, you want to add some provision, do it, but did not to disturb the basic structure of the constitution. And they gave the list of what is the basic structure, and also they said that this list is not exhaustive. It is not the end. As per the time, more and more points will be added to the list, and this is not the exhausted list. Okay, so let us go and see what are there in the basic structure of the constitution and what does it include. The Supreme Court said that that the given list is not an exhaustive list, but over the time, multiple cases, it has identified several basic features. Some of the basic features that is listed over here are Supremacy of the constitution, that at any point in any case the constitution would be supreme. Republican and democratic form of the government is also the basic feature of the constitution and it should not be amended. Secularism is also a basic feature. Tomorrow you cannot amend the fundamental right under article 25, 28. Because why? Because secularism is the basic feature. Separation of power, judicial review, we will talk about this, why the Kesavananda Bharati case is very important, because judicial review is also the basic feature of the constitution, and we will talk about this also. The federal character of the constitution and rule of law, free and fair election, independence of the judiciary. Tomorrow you cannot amend the election part of the constitution and you say that yes, tomorrow there will be no election or the manner of election will be changed. Cannot say that. In the fundamental rights, exclusively mentioned in the list, parliamentary system, balance between fundamental rights and directive policy of the state policies and direct principle of the state policy DPSP. So this the balance between the fundamental rights and DPSP is also very important, and we will discuss as we proceed on with this course. So now you see Article 13 Clause 2 subclause 2 says that the Parliament cannot make any laws that changes or abridges or takes away the fundamental right. But in Kesavananda Bharati case 1973, the parliament, the court ordered or the court said that the parliament cannot amend the constitution and cannot amend the constitution, not only the fundamental right, but other thing as well. And that they termed as the basic structure. That you do whatever you want to do, but do not touch upon the basic structure of the constitution, which is the pillar of the nation. Understood? So this is why the Keshwananda Bharati case is very important. And also remember that this is not an exhaustive list. More and more feature would be added over the period of time. But up till now, remember this thing. So did I say that the judicial review is very important and it is the basic feature of it is the basic structure of the constitution. It is added under the basic structure of the constitution. And the reason why I say this is hidden in the first amendment of the constitution, where we have inserted schedule 9 in the Indian constitution. Now if you go to the PDF version of the constitution and read schedule 9, you will see the act in the schedule 9. The schedule 9 is basically contain the list of the laws that could not be challenged in the court. That is, every law is open to judicial review. Tomorrow if you pass any law, that law will have to be, you can place that law before the Supreme Court and say that, sir, see whether this law is appropriate, this law passed the test of the constitution or not. And if it does not pass the test of the constitution, obviously you have to nullify the law. But those law which were placed under the schedule 9 of the Indian constitution will not be under the judicial review. It cannot be taken up by the Supreme Court or any other court, and can be test on the basis of the constitution. So now let us discuss the Schedule 9 of the Indian Constitution, and what were the reason of bringing in the Schedule 9, and what were the consequences of it, and how does the Schedule 9 evolve. Let us discuss all this point. So starting, we know that the Constitution was enforced on the 26th January 1950, and that is on the very edge of the independence. But there was a huge diversity that we have already seen. There was the major problem and major issues that was to be addressed. And some of the major issues was, number one, there was huge economic inequality. And what was the reason? The reason was the land settlement system followed by the Britishers, and the one of the majorly followed land settlement system was the zamindari system. Okay, in zamindari system, the large portion of the land were owned by zamindar, and the peasants were zamindar, and the peasants were landless. The farmers were landless. So there was a huge gap between the zamindar and the peasants. That is the huge economic inequality. So there were three major objectives after the independence and after the enforcement of the constitution. That is, the three major objective before the government was, number one, to remove the zamindari system. You have to remove the zamindari system because this was inappropriate and result in the accumulation of wealth in the hand of few. You remove the zamindari system, then you distribute the land, distribution of the land among landless farmer, among these peasants, and this would what? It would reduce poverty. We have to reduce poverty and you have to promote equality. So also, if you have to achieve all this, if you have to reduce the poverty and increase the equality, if you have to ensure the distribution of the land among the landless, that were the peasants, then you have to make laws. Who will do that? If there is no law, we in the very first video, in the very first lecture, we have said that if there is a law, everyone will abide by the law, but the law must be just and in compliance with the supreme law of the land. Now you have to make the law. So suppose there was different laws that were passed. That is the Land Sealing Act. That says that nobody could hold a land above a threshold limit. That is, suppose Zamindar A is having a land and he is having suppose 100 acres of land. Now, when the Land Sealing Act was passed, and suppose the upper threshold was suppose say 50 acres. So if Zamindar A is in possession of 100 acres of land, so obviously he cannot possess more than 50 acres of the land because a law has been made in the country. So what would be the result for the remaining 50 acres of the land? This 50 acres of the land would be redistributed to the landless. So now if you think from the point of the Zamindar A, it is his property which is taken from him and it is distributed to the landless. And that is a clear-cut violation of Article 14, right to equality, as well as Article 31 that we have discussed above. That is the state cannot deprive you of your private property except by the law and with the fair compensation. So if these two fundamental rights are violated, obviously the maker of the law knows that they will be challenged in the court, and there were several challenges to such laws which was passed by the parliament for the redistribution of the land, for the reorganization of the land, was challenges challenged in the court. And one such case was Kuwar Singh versus State of Bihar. That was the sorry, not Kuwar Singh, Kameshwar Singh. Kameshwar Singh versus State of Bihar. And obviously this was in the year 1951 and against the Land Reform Act, was against the Land Reform Act. Land Reform Act. And what would be the decision given by the court? Yes, obviously, the court will give a decision that such law will be null and void because it violates Article 14 and Article 31, and that is the duty of the court to check whether the law passed by the legislature is in compliance with the supreme law of the land. And if it is not in the compliance, we'll have to strike it down. That what the court did. Now, any law you pass to achieve this objective, that is to remove zamindari system and to achieve these objectives, that will be definitely will be struck down by the Supreme Court or by the court if it is challenged in the court, because this is clear-cut violation of the fundamental right. But you have to achieve this objective because it is necessary for the social reform in the country, and that is very much required at that point of time. So the constitution was amended and Schedule 9 was inserted. The constitution amended and there were one article 31 clause b was added in the constitution, and it says that any law any law placed under schedule 9 any law placed under schedule 9 will be protected from judicial review, will be protected from judicial review. And then they added a schedule 9 which contain the list of all such law. अब झमेला ही खत्म हो गया भाई। आप कोर्ट में चैलेंज कर रहे थे ना, एंड कोर्ट के पास भी कुछ हथियार नहीं था। इट विल टेस्ट अकॉर्डिंग टू द कॉन्स्टिट्यूशन। तो कॉन्स्टिट्यूशन को ही अमेंड करके उसके अंदर एक आर्टिकल ऐड कर दो, आर्टिकल 31 क्लॉज बी, और उसके अंदर लिख दो कि भाई ऐसे जो भी कानून जो हम बनाने के बाद उस कानून का नाम एक शेड्यूल 9 ऐड कर देते हैं, क्योंकि जब ओरिजिनली कॉन्स्टिट्यूशन पास हुआ तो 8 ही शेड्यूल थे। एक नया शेड्यूल बनाते हैं, शेड्यूल 9, और उसके अंदर हम जिस भी कानून का जिक्र कर देंगे उस कानून को कोर्ट के प्रीव्यू से बाहर रखा जाएगा। ऐसा तो हम कर ही सकते हैं, हमारे पास कॉन्स्टिट्यूशन को अमेंड करने का पावर है, लेजिस्लेशन। तो लेजिस्लेचर ने, जो पार्लियामेंट है, उन्होंने 31 क्लॉज भी ऐड किया, और उन्होंने बताया कि इस बी के अंदर इसमें जो भी लॉज पास किया जाएगा दैट विल बी, और उस लॉ को अगर हम शेड्यूल 9 में प्लेस कर देंगे, दैट शुड विल बी अंडर द प्रोटेक्शन फ्रॉम द कोर्ट। दैट इज नो कोर्ट विल हैव पावर टू रिव्यू दैट लॉ। You cannot review that law whether that law is passing the test of the constitution or not. And schedule added the schedule 9 in which such laws were mentioned. And because that at that time all these laws were was related to the like the social reforms, and that were important. So now if you make any law and you place them in the schedule 9 of the constitution, and somebody challenges that my law, this is the violation of my fundamental right, then court will see that there is a clause in the constitution, that is 31 clause b, and it says that those law which are placed in schedule 9 should not be reviewed. So the court will say that okay, this law, although it's a violation of the fundamental right, I cannot review it. So if you are filing a case against this law, but this law is it protected under the schedule 9, I cannot review it. So I do not know whether it is violating a fundamental or right or not, because the constitution itself prohibit me to have a judicial review of that law. But later on, it was observed that the parliament has made Schedule 9 as a tool. They passed any law, whether it was related to judicial reform or not, or social reform or not, and they placed that law in Schedule 9. Now, if this would be the process, and if this process would goes on, then what will happen? You can make any laws, whether it is related to social reforms or related to any other thing, or favoritism, or giving privilege to any other particular class. And you just mention that law in Schedule 9, and you will say that court has no power, the court will become powerless. So that the Kesavananda Bharati case, where I said that judicial review become what? Judicial review become the fundament, the basic structure of the constitution. And what? You cannot make an amendment which which amends the basic structure of the constitution. So that amendment, that is article 13 clause b, which is what it is saying, it is changing the basic structure of the constitution. Which feature? The feature of the judicial review. And it says that no law placed under schedule 9 will be judicially reviewed. So after this judgment was given, this 31 clause b comes in contradiction with the basic structure of the constitution. And therefore in IR Coelho case, it says that from now onward, the date of the judgment of the Kesavananda Bharati case, that is 1973, any law that is passed that is passed after 1973 and it is placed in Schedule 9 in the Indian Constitution is not protected and will be judicially reviewed if it violates the basic structure of the Constitution. So you remember why I shared that they said that the judicial review is one of the important basic structure, because after this judgment 1973, and this become in contradiction to the article 31 clause b, and therefore it is now in IR Coelho case, it is said that any law which is in contradiction with the basic structure of the basic structure of the constitution, and it is kept under the schedule 9, shall not be protected. So as of now, what is the current status? It says that if you make any law, and if that law is violating the basic structure of the constitution, that law shall not be protected under schedule 9 of the Indian constitution. Oh, I hope you understand why Kesavananda Bharati case is of so much importance in the history of the constitutional amendments, and why this basic structure doctrine is very important. So with this, we'll now proceed to the PYQs and some MCQs to revise the previous video on the preamble. So let us start and quickly complete the set of questions that I have for you. The one is the question which was asked in IS 1993. It is said that in one column we have the features of the Indian Constitution, and in the list two you have to see from which country it has been borrowed. The fundamental right, you already know, it is borrowed from United States. So A2 parliamentary system is from the United Kingdom. So you'll see this option will matches. Emergency provisions is taken from Germany, and directive principle of state policy is taken from Ireland. Similarly, the concept of fundamental duties has been taken from the Russian Forward Soviet Union. Which one of the following is not correctly matched? C. The fundamental rights is taken from the USA. This is correctly matched. Directive principle of state policy, Ireland, correctly matched. Residuary power to the center, correctly matched. Emergency powers. Residuary power of the center is not Australia. It is not Australia. Sorry, it is from the Canadian Constitution. Residuary power to the center. So this is the not correctly matched. Then moving to the next question, again you have to do the same thing. Directive principle of the state policy is from the Ireland. So for A you have the option number 3. Fundamental rights from United States of America. That is for B you have option number 5. And then concurrent list and union state relation. Concurrent list is from Australian. For this is 1. And India as a union of state with greater power to the union is from the Canada. So 3512 is the correct answer. This is option number D. From here also, let us see the rule of law. The rule of law is and the procedure established by the law. The rule of law is taken from the which constitution? It is either Japan. The concurrent list is taken from the Australia. For D, we have what? We have 1. And rule of law is there is actually rule of law is taken from England, and the procedure established by law is taken from the Japan. And so this would be 3. Rule of law is from England. This will be 2. Reservation of bill by governor for the president consideration. That is will be taken from this is option 4. This is 4. So this will be 32341. This is D. See, when we talk about the Canadian Constitution, we have said that only those things, C for Canada and C for center, which shows center in higher power, that is appointment of the governor by the center, residuary powers to the center, reserving of the bill of the governor for president consideration. That also emphasizes the power of the center is taken from the Canadian Constitution. And from Australia, we have said that A for Australia and A for all. So, if anything which talks about the joint or collaboration between the center and the state, that is concurrent list, or the other thing that is joint sitting of both the houses, will be from the Australian constitution. So, let us move forward and see the other questions. Which among the following is not the correctly matched? Citizenship is part 2 correct. Union territory, part 7. Municipalities, 9A. Union territory is not part 7, it is part 8. So this is not correctly matched. Consider the following. The Constitution of India has 20 parts. It does not have 20 the parts. Either it has the 22 parts. There are 390 articles. No. In the very beginning, it has 395 articles. Now more than 470 articles. So 1, 2 is not correct. Only 3 will be correct. If new state of Indian Union is to be created, which of the following schedules of the Constitution must be amended? It is schedule. It is the Schedule 1, which basically talks about the list of the details of the states and the Union territory. Which one of the following schedule of the Constitution of India contains provision regarding the anti-defection law? This is the 10th schedule. Although you have not done through it, if you go through the schedule of the Constitution, we have done the schedules in the previous part. You will see that the Schedule 10 talks about the anti-defection law. Which one of the following schedules of Indian Constitution lists the name of the state and specifies their territory? It is the first schedule. Under which schedule of the Constitution of India can be transfer of tribal land to the private parties for mining and declaring? Under which schedule of the Constitution of India can be transfer of tribal land to private parties for mining be declared null and void? It is the fifth schedule. Go through the schedule, see how many questions are coming from the different schedules of the Constitution. You go through the schedule, and then most of many questions of this type you will be able to solve. Then the preamble of the Constitution of India is a part of the Constitution, not a part of the Constitution. We have seen that it is a part of the Constitution. So it is a part of the Constitution and has the same legal effect as any other part? No. It is a part of a Constitution but has no legal effect. That is correct. But let us see the other statement as well. A part of the Constitution but has no legal effect independently of other part. That is true. If we talk the preamble as in is in isolation, it has no legal effect. But in case if it has, there is some ambiguity in any of the provisions of the our constitution articles, then you can take reference from the preamble to interfere that article. So independently, yes, it has no legal effect. What was the exact constitutional status of India on 26th January 1950? See, 26 January 1950, that means the preamble was not amended. So it was a democratic republic, it was a sovereign democratic republic, it was a sovereign secular. Secular was added as a amendment. Socialist was added as an amendment. So it was a sovereign democratic republic. The provision of the fifth and sixth schedule in the Constitution of India are made to. It is related to tribal areas and the scheduled areas. Protect the interest of the scheduled areas. Determine boundaries between the state. Determines no. It is for the scheduled tribes. In which form is India declared in the preamble of the Indian constitutions? This question is basically overlapping. So it is a sovereign democratic republic. Now, which one of the following reflects the most appropriate relationship between the law and liberty? Law and liberty we have discussed already. That is, if there are more laws, there is less liberty. No, if there are no law, there is no liberty. Obviously, if there is no law, there will be no liberty. The term socialist was added in the preamble by the 42nd Amendment Act of 1976. The mind of the maker of the Constitution is reflected in which of the following? A very easy question. The answer would be the preamble. Which one among the following called the preamble of the Indian Constitution as the horoscope of our sovereign democratic republic? Horoscope of our sovereign democratic republic is basically Dr. B.R. Ambedkar. He says that it is the horoscope of our sovereign democratic republic. Also, sometimes the name of K. Munshi is coming, but Dr. B.R. Ambedkar has said that it is the horoscope. The main advantage of the parliamentary form of the government is that the executive and legislature work independently. It provides continuity of the policy. No, the executive remain responsible to the legislature, obviously. We have discussed all this thing. If you are not able to recall it, please watch the previous video so that you will able to answer all this question. All this part has been already discussed. The parliamentary system of government is one in which all the political parties in the parliament are represented in the government. To some extent, true. The government is responsible to the parliament and it can be removed by it. Also true. The government is elected by the people and can be removed by them. No. The government is chosen by the parliament but cannot be. No. So option A is also correct. Option B is also correct. Now you see which among the two are the major part or the most important part of the parliamentary form of the government. That is, the government is responsible to the parliament and can be removed by it. All political parties in the parliament are represented in the government. That is true, but that is conditionally true, not always true. It may happen that some political party did not get any representation because they have not been elected. So that means conditionally true, but this is always true. The government is always responsible to the parliament and can be removed by it. The constitution government by definition is a government by legislature, is a popular government, is a multi-party government, is a limited government. It is a limited government. It is not unlimited government. It has limited powers. In the context of the India, which of the following principles are applied institutionally in the parliament government? What is the parliamentary form of the government? The members of the cabinet are the members of the parliament. It is true. Minister hold the office till they enjoy the confidence in the parliament. True. The cabinet is headed by the head of the state. Now, this statement is ambiguous. Option 1 and 2 is 3, correct. But for option 3 to be correct, the cabinet is headed by, we know that it is headed by the prime minister, and prime minister is the real head of the state. Real head of the state. But the head of the state is who? Head of the state is the president. If we talk generally, the head of the state, he is the president. Yes, president is the nominal head of the state, but in general, he is the head of the state. So if this statement means that the cabinet is headed by the head of the state, that is the president, this statement becomes false. Okay, so this is all with respect to today's video. I hope we have sufficiently explained the important case, Kesavananda Bharati case, and all this question that I have covered today is from the previous video. And I hope if you have listened to the lectures carefully, you would be in position to solve all this question. So thank you very much for being with me and listening to me patiently. In the next video, we are going to start with the union and its territory. Thank you. Have a nice day.